Trump knew that he lost. He saw the results. Everybody was telling him, yeah, you lost, all over the place. And he disregarded that, acknowledging his loss, but saying, I'm going to steal it anyways, which obviously never happened. Or reveal any threats that actually impacted the election's integrity. It's just crazy. That's not the standard. Trump doesn't have to believe that something actually impacted the election in order to believe that. If there were agents there who should have stopped an insurrection and failed to do so, or they caused it, not Trump. It's about causation. Judge Chutkan, the judge in the January 6th case, is blocking Trump from getting evidence that he needs to defend himself in the very important January 6th prosecution. Of course, it's being brought by Jack Smith, who is an illegitimate prosecutor, but the judge has been battling with Trump over this issue. Two main questions that we've been grappling with here. Number one is, what is the size of Jack Smith's prosecution team? Who's involved in it? Jack Smith wants to keep that very narrow, whereas Trump is saying it involves everybody. It involves the NSA, it involves Homeland, it's the FBI, of course, but it's not just one office, it's much broader than that. Very expansive. And he's also saying that I need access to specific information, particular discovery, particular evidence about things that happen, so that he can use that to create a defense for himself, or to develop a defense for himself that has already existed because he didn't do anything wrong. And part of this is going to go to his mental state, his mens rea. What was Trump thinking? So let's go through it. So we see what the judge is doing. It's Judge Tanya Chutkan out of the District of Columbia, writing, Trump has filed a motion to compel discovery to force Jack to give them evidence, and another motion for a decision about the size of the prosecution's team. Who's on the team? Because if they're on the team, then they're fair game and we get evidence. Now, collectively, these motions are seeking materials from 9 government entities, and they want 14 categories of government information, right? Very broad. Trump wants a lot of material because, you know, he was the president at the time. He was at the top of all of those agencies. So he was communicating, or at least purview to the communications and the updates of all of those agencies, and making decisions based on the materials that he had from his position at the time. So he wants to go get it. Now, for the reasons set forth below, and in a classified supplement that's going to be distributed to the parties, the court, says Judge Chutkan, is going to grant, in part, some of Trump's motions, and deny that, and require, if Jack doesn't give you the materials that I'm going to give to you, that you file a motion to compel other discovery, immunity-related discovery, by October 30th, 2024, here at the end of the month, which we'll come back on. So here's the background. Now, the judge says, all right, look, the government, the prosecutor, Jack Smith, he's illegitimate, but the judge hasn't addressed that yet, even though Cannon threw him out, and there's questions about his oath and other things. But she is now going to walk us through some background. She says, all right, look, Jack, right now, at first, he must comply with 2 related discovery obligations, all right? Number 1, Brady materials. We know what these are. These are exonerative materials. The government has an affirmative duty. They have to actively disclose this stuff to the defense. If it's favorable evidence to the defense, you got to give it up. If it's exculpatory or favorable evidence that's in your possession, the government holds all the cards, right? So we know what it means. Now, that includes all favorable evidence, and it needs to be disclosed. Now, Brady also imposes a duty to learn of any favorable evidence known to the others acting on the government's behalf, including the police. A duty to search files maintained by the government that closely align with the prosecution if there is enough of a prospect of exculpatory materials to warrant a search. Now, the scope of that duty depends on the working relationship between the prosecution and the agencies, right? The nature of the files. And the government always comes back and says to the defense, this is a fishing expedition. You just want everything from everybody to delay the case and just go find something that's problematic. But if you want to show, and this is where things get a little twisted, if you're a defendant now and you want to say, well, they're violating my Brady rights or they're not giving me exculpatory evidence, now you have a burden, right? Now you have to go and prove that. The showing must identify the withheld evidence that is material and favorable to the defense, stuff that's not merely cumulative. It also can't just be speculation, like, well, I think there's something in there, and so let me see. That's number 1, right? That's Brady. Now, the government must also produce certain documents if requested by the defense under federal rules of procedure. They say, well, they must permit the rules a defendant to inspect, copy certain materials that are in the government's possession if it is material to preparing for the defense. And so the rule obligates the government to search for its files and produce evidence that they say is material to the defense. Defendant Trump, in this case, bears the burden of demonstrating that materiality, right? So Trump has to say, all right, well, if I want evidence from the CIA or from the NSA or whatever, I got to show that it's specific and it's material. And of course, these are terms that are highly subjective, and so the judge will just interpret them favorably to her. So she writes, well, it is not a heavy burden burden for the defense to have to do that, he must point to at least a strong indication that it will play an important role in uncovering admissible evidence, like aiding a witness or corroborating testimony or helping with impeachment. In other words, the government needs to disclose only if it enables the defendant significantly to alter the quantum of proof in his favor. So it's not just kind of a loosey-goosey file, hey, give me everything in your records, government. They must show a tenable relationship between the materials that are sought and their case. And so judges have applied the different rules, okay? Now we know the rules. So Trump filed his motions, and they say Trump contends that Jack Smith and his illegitimate bunch of deranged thugs has failed to comply with its discovery obligations under those two rules. They say in the motion to compel, Trump cites that they gave discovery requests. They said, we want this and this and this and this to 14 categories of information that he says the government has failed to produce. Now, Trump's motion on Jack's prosecution scope, the size of his team, says that the prosecution has to search for this, all right? Also, other Jenks Act material, which are other reports and notes and other things that a witness might rely on in preparation for testifying. Although his arguments span two motions, they're going to consolidate them now. Essentially, Trump wants an order. They want an order for Jack Smith to search the government entities and produce information that Trump believes he's entitled to. Now, relying on internal policies at the DOJ, Trump says that the search should include a review of any relevant files at law enforcement agencies that may contain discoverable information. That includes a bunch. Investigative agencies' entire investigative file, including like the FBI electronic communications, inserts, emails. He wants those. He wants substantive case-related comms. He also says the government should conduct prudential search requests at agencies and components that may possess discoverable material. So expand the scope of the search to other agencies that may be working with the main agency. Now, whether under Rule 16 or Brady and its related obligations, the government's duty is bounded by the materiality, including the favorability to the defendant, and the government's control over that information. So they're kind of balancing those things. Now, as noted above, we're going to talk about those two issues. All right, first, materiality. Judge Chutkan writes, all right, 5 of the 14 categories of the information that Trump wants are asking for specific, discrete, identified documents. The remaining 9 categories are generic for all information or evidence related to certain topics. Now, as explained below, Trump has only carried his burden with respect to a small portion of the information he seeks, but he's going to get some of it. But for most of it, he has proffered only speculation that a search will yield material. He's like, if we search, we'll get it. But that's it. So it's only speculation, right? She's going to nuke the rest of it. Moreover, while Trump purports to seek much of this information to show his state of mind, right? They're saying that Trump was defrauding the country. Trump knew that he lost. He saw the results. Everybody was telling him, yeah, you lost, all over the place. And he disregarded that, acknowledging his loss, but saying, I'm going to steal it anyways, which obviously never happened. He said, I didn't lose, has never said that he's lost, acknowledges that Joe Biden is the president right now, but the election was rigged, as we've covered here extensively in, I don't know, 100 videos at this point. So he wants to say, no, okay, I was getting this report and this report and this report. And if we go search in these domains, we'll find them. And I can present those as evidence of my mind at the time of his indicted conduct. So it's critical to his defense, his good faith, his absence of criminal intent. He wants to show that he disagreed with officials now favored by the prosecution, and he relied on his own independent judgment, which he's allowed to do. He's the president. Okay, that's like the prime job of the president. It's to listen to a bunch of experts and say, no, you're wrong. No, we are going to do this thing. And then the historic presidents are the ones that make the hard decision when everybody else around them is barking in their ear. Trump believed the election was stolen because it was. He does not indicate that he was aware of the requested information such that it could have affected his state of mind, they say. Now, consequently, with a few exceptions, the court cannot compel the government to search for or to produce additional documents. So this is her justification. Here is what Trump is referencing specifically. Okay, so if she says he can get it if he references it specifically, is she going to give it to him here? Let's see. First, Trump seeks a complete classified version of the election ICA assessment and all source materials, including assessing Russian activities, the analytic process and cyber incident attribution, and more. He claims that information relating to a significant escalation of foreign influence in 2016 motivated him and his administration to focus on foreign influence and cyber risks, rebutting the allegation against him that his actions between November and January were motivated by a desire to maintain office, right? Jack says, you were there for unlawful reasons. You wanted to stay there forever. He says, no, I was motivated by foreign influence as one motivation. He says that in 2016, the election ICA contradicts the allegation that he eroded public faith in the administration of the election by disclosing foreign efforts to accomplish that erosion. Now, Now, the government says that the classified ICA is immaterial because it relates to a different election, and that the defense seeks closely guarded secrets of national security about the illicit activity of actors who were not implicated in the indictment. So Trump is saying, look, if we go back to 2016, I'll show you that there's history of this problem, right? And that is showing a pattern that Trump's relying on 2016 to make his decisions in 2020. They say there's no meaningful connections. It's a different election. Now, so then Chutkan says, well, okay, well, Trump has not carried his burden. There's no adequate basis for inferring that those documents from 2016 are going to contain any material info. He already has access to the unclassified version of that, and its conclusions, they say, are identical to the highly classified assessment. So why is it so highly classified? What happened in 2016? Now, cumulative information generally does not mean he gets it again, and so he hasn't demonstrated a need for it. He needs something that's going to yield material fruit. Just mere speculation ain't enough. Now, also, Trump fails to explain how classified records related to 16 could bear any motives for his acts he allegedly committed years later. Well, he's making judgments on this election based on patterns he saw in a prior election. That's why. It's like if you get punched in the face once, you learn how they're throwing that hook. And when they start to throw it again, oh, I've seen that before. Yeah, let's go back to the tape and see what oh, there it is. Okay, there's that. Trump does not claim to have reviewed the records he seeks, their sources, or their conclusions before during the time period of his indicted conduct, nor does he proffer that the information therein was relayed to him from someone else. So she's just saying he didn't see it specifically, right? Even though he's the president. There is no basis, accordingly, for this inference that classified portions of this were a part of his mental state in making the decision. So I don't know if Trump saw it or if his defense attorneys had that conversation with him, or if this is a drafting oversight, or they chose specifically not to include that proffer in there. Maybe they tactically do not want to make that explanation to the prosecution that this is his defense. They also want statements from CISA. Second, Trump seeks information that undercuts the categorical claims in the 2020 election CISA statement. In particular, drafts of the statement that contained narrower language and communications related to revisions. So first draft of the CISA statement was kind of weak, like, this election wasn't that great. The superseding indictment refers to that statement in alleging that the 2020 election was the most secure in American history. Gag me, just like everything else is so amazing from these people. And that there was no evidence of any voting system deleted or lost votes, changed votes, or was in any way compromised. That's from their second draft indictment. First one they screwed up. Trump says that the records he seeks will bolster his argument at trial that the 2020 election CISA statement was part of a partisan effort to provide false assurances to the public that outpaced the government's understanding of the situation. They're like, get a statement out. The election was incredible. As with his first request, however, Trump presents nothing more than mere speculation that any earlier drafts and communications will undermine its final conclusions. His only attempt is a reference to SolarWinds, saying that there was Russian hacking there and there was insertions of malicious code. Trump also claims that the SolarWinds attack renders the CISA statements implausible, but he says there's no link between SolarWinds and the election or 2020 at all. And so there's no indication that CISA having multiple drafts of their statements, making it worse every time for Trump, making it more and more propagandistic every time. He doesn't need to get it. Also, it doesn't link to his mental state. Trump seeks to characterize that statement as partisan to rebut the indictment. The indictment says everybody was saying it was fraudulent, and he was ignoring that. But they say at the time of his indicted conduct, Trump would only have had reason to believe the statement was partisan if he knew about information like that he requests here. And if he would have proffered that he had seen the narrower drafts, then maybe would have given that to him. But he hasn't done that, and so there's no strong indication that he should get any of those materials. Now, Trump also wants the 2020 ICA for specific types of records relating to the intelligence community assessment of the 2020 election. Here's what Trump wants. All drafts. They also want communications about the drafts. So who requested the changes and what did those look like? All information and materials related to Dr. Zuloff's conclusions about the evidence of the efforts by, quote, CIA management to pressure analysts and suppress reporting. That's a curious one. And the additional materials discussed in the classified supplement. Yeah, that's would be great to have. Trump wants materials about Dr. Zuloff and his conclusions that CIA management was pressuring analysts to suppress reporting. The same CIA that was colluding with those 51 intelligence experts to spread propaganda to stop Trump by their own admission, that CIA. Trump hangs the materiality of those records on the original indictment's reference to the intelligence community findings, right? Jack says they all said it was totally fair. He says these are material because they use these to impeach the statement statement from them, right? CISA came out and says the election was amazing. They said, no, it wasn't. This other statement, Dr. Z, he came out and said it's terrible. And the CIA was pressuring us to shut up about it. But even as applied to the original indictment, these arguments are flawed, says Judge Chutkan, of course. Says the logical chain between these records and Trump's concerns about the integrity lack the crucial link, which are Trump's awareness. He does not indicate that he knew about these records or their contents at the time, and so they couldn't have helped him inform his opinion on January 6th. Now, by the same token, these records can only impeach the 2020 election CISA statement, which is apparently evidence that Jack Smith is going to bring in, to the extent that they contradict his state of mind. And the records could not have affected his state of mind if he did not know about them. And he provides no reason to believe that anything in there could be used to impeach CISA anyways. And so the motion to compel cannot be based on speculation. And so the new indictment is even less involved with those claims. And so he doesn't get those materials either. Now, in addition, Trump does not indicate that the records contain material beyond what he's already received. The government reports, in addition to the public and declassified election ICA, Trump has already received 2 classified versions, the final draft and an earlier draft. Trump gives no basis for the inference that other drafts or communications about revisions would contain any other material. Wait a minute. He's already got an earlier draft, so just give him the rest of them. He cites to 2020 the minority view, which suggests in the ICA that China took at least some steps to undermine Trump's re-election chances. You're kidding. Meeting the definition of election influence, but not that China tried to interfere with election processes. So they didn't interfere with election processes, but they took some steps, right? So Trump says, well, there you go. Now, accordingly, Chutkan says, well, the minority view doesn't indicate that anything in those prior reports are going to support Trump's claims. The same is true of records related to the public report from Dr. Z. Trump focuses on the report's comments on efforts to suppress alternative analysis about China and their attempts to conduct election influence. But he draws no connection between those efforts and this case, much less explains why he needs classified information that's related to those. The report itself notes that the efforts took place before the charged conduct in this case, right? And that the alternative analysis itself was ultimately published. Now, without more, the judge says you're not entitled to that either. And so you can see the list goes on and on. Trump also wanted the 2020 DOJ Homeland Report. In this declassified version, the report found no evidence that any foreign government affiliated actor prevented voting, changed votes, or disrupted the ability to tally votes or transmit election results in a timely manner, altered any technical aspect of the voting process, or otherwise compromised the integrity of voter registration information of any ballots cast during 2020. Now, despite this finding, which is from Homeland, which was in on it, Trump argues that the report and their classified details will support his defense that he had good faith concerns about the integrity of the election. So, well, that's what their conclusion was, but read the rest of it. But while Trump cites snippets from the report indicating that its authors considered several potential threats to the integrity, he omits that the report refuted all of them. For example, he highlights several incidents with Russia, China, Iran, material things, but he ignores. He says they concluded it didn't materially affect the integrity of the voter data. And apparently it does say that they materially impacted, right? The report says there were several incidents when Russian, Chinese, Iranian government affiliated actors materially impacted the security of networks associated with or pertaining to U.S. political organizations, candidates, and campaigns during the elections. And broad Russian, Iranian campaigns targeting multiple critical infrastructure sectors did compromise the security of several networks that he managed and that managed some election functions. Wow. But he ignores that those efforts did not materially impact or affect the integrity of the voter data, the ability to vote, or the timely transmission, right? That's their conclusion. The report says this was happening. They say it didn't materially affect the voter data, but the report says it happened. Now, we can debate materiality. In fact, we're doing that right here. But Trump relies on the report's acknowledgement of multiple claims about this, but he doesn't offer anything beyond speculation that the details will impact or reveal any threats that actually impacted the election's integrity. It's just crazy. That's not the standard. Trump doesn't have to believe that something actually impacted the election in order to believe that. The larger problem with this request is that once again, Trump has not proffered any indication about the classified details that it could have affected his state of mind during the alleged offenses. He argues that he was not obligated to the report's assessments or determinations at the time. Yeah, like Trump, well, why did you do what you did? Well, I read a report on April 5th, 2018 that said the following, and it was, no, right? It's like he's the president. He knows these things and makes decisions based on everything that comes into him. That's what the executive does. Now, that may be true true, but the information Trump now seeks could not have prompted him to discredit those assessments unless he knew about it during the relevant time period, and he doesn't make that claim. Instead, he argues he must be permitted to draw attention to good faith, non-criminal disagreements about the conclusions, right? The other alternative is not infallible. It's subject to opinion. And Trump was the elected president at the time, enabled with the power of the people to make those discretionary decisions. Chutkan says, even the original indictment did not refer to the intelligence community's findings as infallible per se, but as evidence, right? All of their opinions, which are fake, rigged opinions, just like their 51 intelligence agents letter, it's made up. They use it to say that Trump knew that his claims of election fraud were false because he was notified that his claims were untrue. I don't care. We were notified that Hunter's laptop had all the hallmarks of Russian disinformation. No one cares about their stupid statements that they proffer as true. Trump didn't either. Turns out Trump was right. We're learning more and more every day about how bad it actually was as we're going into this new one. Often by the people on whom he relied for candid advice on important matters, who knew the facts well. He didn't have to believe him. He's right to say thanks for your opinion, dude, but no. And as already noted, the superseding indictment does not refer to those findings at all, instead alleging that his knowledge is based on information that he got from his own running mate, his own campaign staff. Again, they're not the president, so who cares? Trump has given no reason to believe that the report and their classified details would assist him in preparing a defense. His subordinates provided him contrary information, and so she wants to know, well, what magazines did you read to believe that the election was stolen? And I guess she's then going to judge his state of mind, which is also shocking that we've got that happening. Now, fifth, Trump wants records related to the testimony of the former DNI, which I think was John Ratcliffe. Now, the original indictment says the DNI disabused Trump of the notion that the IC's findings would change the outcome of the election. And Trump notes that during an interview by Jack's office, the DNI indicated that he had prepared by reviewing materials maintained by his former employer, right? So Jack was interviewing this person. He read records. Trump argues, therefore, the government must collect and produce all those materials that he referenced, including the classified stuff that he talked about, because you talked to him and he referenced those, so those are ours. Now, while the superseding indictment doesn't claim the same allegation as the new one, the government has not disputed that he is a potential witness, and I think this is what the judge is going to give him. If the materials that he reviewed included some of his own prior statements, which relates to his testimony, then you do have to search for those. So now the question of where the government must search for these materials we'll talk about later. But the court will afford the government an opportunity to argue why it's not required to produce this JNCSEC material until trial. So it sounds like the government is going to have to go and take a look at this. If he's going to testify about those materials, it may be JNCSEC material, right? So I think it's Ratcliffe, but if he comes in and says, yeah, I looked at those things to refresh my recollection, okay, that triggers the disclosure to the defense. So they can review that to cross-examine him, impeach him, and get him to contradict himself against his own testimony. So the judge will then go through some of these generic requests. January 6th responsibility statements. Trump wants all communications and documents in which prosecutors, law enforcement, or other officials made statements that are inconsistent with the prosecution's position about January 6th. Their position, to which Trump refers to, is that Trump is responsible for the events at the Capitol, right? That's what they keep saying. Trump is responsible for all of that. A day that was the culmination of Trump's criminal conspiracies to overturn the results of the election. In Trump's view, that position is contradicted by multiple statements by prosecutors all over the place who are prosecuting the J6ers. Now, they say, in theory, the judge, inconsistent statements by government officials might be admissible. Now, to support the inference that these inconsistent statements exist and must therefore be searched for and produced, they point to several examples of the J6 rioters, protesters. A prosecutor's argument that a defendant could not assert entrapment by estoppel or public authority because he could not identify any remarks made by former President Trump that authorized the illegal conduct, right? This guy says, well, Trump made me do it, literally. Like the president told me to do it, so I thought I had immunity. But they couldn't find anything by Trump who said, go do the illegal thing. A prosecutor said in closing, it is essentially irrelevant in this case what you think about President Trump's conduct on that day, because Trump didn't make them go into the building. And a prosecutor's statement that the president didn't take action in the days leading up to January 6th. The president didn't take action. So Chutkan says, it does appear, however, that these kinds of statements could assist Trump significantly to alter the quantum of proof in his favor. Does not appear. It's not going to help him. Opposing party statements from government agents are only relevant if they're material. Is this going to matter? Is this going to change anything in the eyes of the jury? No. The court is not persuaded that other prosecutor statements even contradict the government's position in this case. It's entirely conceivable, for instance, says the judge, that Trump could share responsibility for the events of J6 without the express authorization of the rioters' criminal conduct, that they could claim entrapment by estoppel or public authority defenses. Likewise, Trump could still share that responsibility, even though he did not take certain actions that some rioters had hoped for, like invoking the Insurrection Act to stop the election and call up the military and stuff like that. Nor is there any contradiction in a prosecutor saying it was essentially irrelevant to this case, keeping all of that out as well, even though the DOJ is contradicting themselves in their own J6 prosecutions. Trump also wants material on all information related to security at the Capitol on January 6, including documents and communications about the request for security and the timing of the National Guard on that day. He said it's material because it suggests that federal and local officials believed that adequate measures were in place to facilitate a peaceful speech, and the delayed arrival of the National Guard contributed to the violence that he sought to prevent. Now, he noted there are public records of a lot of these things, and so with one narrow exception, the court is not persuaded that he's demonstrated the materiality of this. Now, he seeks discovery to support his defense. The defenses genuinely believe the election was stolen, and he had good faith, and he had a total absence of any criminal intent. And that defense might include there was security there. But his request is not limited to that. Okay, so his request is overbroad now. He does not explain why he's entitled to these things. It's overbroad, and Trump makes no efforts to distinguish between the information he already has. And so this is probably cumulative too. And so it's overbroad and it's cumulative. The court disfavors overbroad requests. And so without a more specific showing, he can't get this material. There is one exception. Trump cites a public report that includes General Mark Milley's recollection of a meeting he had just a few days before J6 with Trump and Acting Secretary of Defense Christopher Miller. According to the report, the meeting's primary topic was unrelated to the scheduled rally, but at the end of the meeting, quote, the president told Mr. Miller that there would be a large number of protesters on J6, and Mr. Miller should ensure sufficient National Guard or soldiers would be there to make sure it was a safe event. There, that criminal mastermind Trump, who's going to insurrect the country, is like, make sure there's no riots, please. Mr. Miller responded, we've got a plan, we've got it covered. That should be the case right there. This meeting could have affected Trump's state of mind during the relevant time period, and its contents could thus be material to the defense. Trump does not specify whether he needs additional information regarding the exchange he had, but the government does not mention anything related to it in describing the records that Trump has already received. So the court will therefore give Trump the benefit of the doubt, shocking, and assume that any additional information would not be cumulative. And so accordingly, the court will order the government to search for additional records within its possession concerning information about security measures that was conveyed to Trump during his meeting with Milley and Miller. That is actually really a big one. I think that goes right to Trump's mindset. Trump asked for security. They told him it was secure. And this was all part of a plot to cause a riot to stop the vote. How can Trump cause a riot to stop the vote when he is ordering the DOD to secure the premises? It's the dumbest thing ever. And Milley even acknowledged it. They said, yes, secure it. Now, beyond the points above, that's a big one. Trump adds that security-related disclosures are discoverable irrespective of his knowledge because these materials provide context for Trump, but he doesn't elaborate on that conclusion by explaining how all the materials related to the security would provide context. So at this juncture, no more disclosures. Got to clearly identify it or else. Now, Trump also seeks all information regarding undercover agents and individuals acting at the direction of official authorities at the Capitol on J6. We'd love to know that one. He argues that information regarding individuals who were present in an official capacity is favorable to him because it suggests that there were adequate controls in place and that the violence at issue resulted from a failure of those controls or failed sting operations rather than any directions from him. Judge says the court cannot agree that this information is material. So all of the undercover feds, and we've estimated as many as 50 here based on documents we've read on the screen, but others like Clay Higgins and others have that number, I think, in the triple digits. As with this broader request regarding all security measures, Trump omits any connection between the information he seeks and his state of mind. Well, it's a defense. It shows that he wasn't leading an insurrection. If there were agents there who should have stopped an insurrection and failed to do so, or they caused it, not Trump. It's about causation in addition to state of mind. Whether there were adequate controls in place and that the violence at issue resulted from a failure of those controls could only have supplied the good faith that Trump intends to insert if he knew about those controls at the time, and he does not proffer that he did. The only case Trump cites in support is another case that was already rejected, and so there's no reason to compel the government to search for and produce that information in that case. There was no sign that any of those actors could have affected or did affect the rioters' conduct or their state of mind. So no information about the undercover government agents who were category there. Foreign influence. Now, perhaps the largest category of discovery that Trump seeks to compel is all information related to the foreign influence of 2020, including foreign influence related to the J6, whether he was briefed on it or not. He says he needs it. It rebuts the allegation that Trump created an intense national atmosphere of mistrust and anger, and that he eroded public trust in the administration of the election. Think about how much damage they've done to the elections. It's not Trump, it's Jenna Griswold trying to throw him off. It's Biden and Harris prosecuting him in 4 courts. Supports the defense that Trump and others acted in good faith if certain reports were ultimately determined to be inaccurate. Now, to bolster his claims, he says he's referring to other documents, but again, not material. So we'll see. She's going to make the same pattern as we go through this. Talking about foreign influence, it was about election interference in the indictment, not election influence. It states he spread lies about outcome determinative fraud. So she's kind of narrowing this a bit. It's dozens of claims about dead people, non-residents, non-citizens, voter machines, ballot casts. So it's like they're only upset about some of his statements, but not the foreign influence stuff. So Trump seeks to show that he made his claims of fraud in good faith. He cannot do so by basing that on foreign influence. So he can't even complain about foreign influence because it's just influence. You see, she put that in italics. Now, that leaves just one way in which records about foreign influence might be material if, in making claims of fraud, Trump says that he relied on advice from that, but he hasn't proffered any evidence that he actually got material. Now, how about foreign interference? Trump brings up the sunburst attack and cyber attacks, but evidence of election interference might well be material. But here too, he says he's not pointing to any knowledge at the time. In determining his motives, it does not matter whether there were concerns about the integrity of the 2020 election and the possibility of technical penetrations in anyone's mind but Trump's. Without any proffer of what his concerns are or their sources might have been, his request is too vague to satisfy materiality. Now, he attaches additional materials, and some of the materials are unrelated to foreign cyber attacks, and some of it has to do with Dominion. But discovery requests without proffering any knowledge of the documents that you're asking for means you can't use that to show Trump's state of mind. Trump is not given any indication that would be the case. Same thing with Pence. Next, he wants evidence related to retention of classified documents by Pence. Pence had those classified documents, didn't have his home raided. He had his house searched during a consensual search. They just jumped right into raiding Trump's residence because they said enough already with him. Trump is correct that information suggesting a potential witness's motives may be material. Supreme Court has said that. So some of the Pence stuff will come in. The obligation is limited. The government maintains that they don't need to do this, but the court will order the government to search for and produce any additional information responsive to the Pence stuff. Only though, as so far as it's in your control. Same thing with Biden. Relatives or associates with the Biden administration, they want certain materials. No, mere speculation on this. FISA information. He wants to know how the FBI violates FISA. Neither of these arguments are persuasive, so he's not getting those materials either. And finally, Trump is asking about prosecutorial bias and misconduct. Now, the court has already considered this. Accordingly, Trump has not carried his burden. And so, the court concludes only 3 types of information are material and discoverable. These 3 things only. Materials that the DNI reviewed before his interview, records about the security measures that was conveyed to Trump during his meeting with Milley and Acting Secretary Miller, and that's the big one, and then evidence related to the classified docs that Pence kept. Otherwise, everything else. Some things will still develop, but otherwise, that's it. Now, the size of the prosecution team is also very narrow. First, Trump says that the prosecution team includes the entire Jack Smith office and the Southern District of Florida. Both parties make valid points, she says, but the government wins. Trump has not identified a single document from Florida that is also discoverable here, and so they're separating their cases. He also says it should be everybody in Washington, D.C. Everybody. But here too, the government doesn't dispute those statements. We do use a lot of those people, but on these proffers, the government's actual discovery obligations extend only to a limited subset. So even though it is very broad, we're still only going to give you some narrow materials. The court concludes you only get 2 types of files from this office: communications with and information transmitted by Jack to DC, and any other DC cases and files used in this case, right? So you don't get access to the whole DC office, just some of the people from the DC office who interface with Jack. Same thing with the DOJ. The Attorney General, the Deputy Attorney General are not a part of the team, okay? Even though Merrick Garland has had his hand up Jack Smith's puppet booty, and then Joe Biden has had his hand up Merrick Garland's puppet booty. Even though that's happening, only Jack Smith is on the team. Merrick Garland is not. Lisa Monaco is not. Glad we didn't have to do the puppet an analogy with her. Now, that fact has no bearing on whether their offices have been acting on Jack's behalf, and so Trump has not shown that it expands beyond just Jack's team. As for the NSD, the National Security Division, Trump observes only some of its personnel have prosecuted J6 rioters and seditious conspiracies, so some of the Proud Boys people, maybe the Oath Keepers. That conduct doesn't show that they're acting with Jack Smith, and so some of the people in the Inspector General should be considered part of the team, but that's it. So very narrow interpretation. Same with the FBI. Trump says we should also go into the entire field office in Washington because they shared evidence about the Oath Keepers and the Proud Boys. But the fact that the Washington field office participated in some of this renders at least some of its files accessible. Now, the court will accordingly order the government to search those files at that FBI and deliver what is necessary. Now, similarly, all of these other agencies are not going to be considered part of the team. Trump says the Secret Service should be a part of it, and Homeland is not a part of it. CISA is not a part of it. The government says we don't have much from Secret Service. Their apparently limited and compulsory production of evidence contrasts with these other cases. Trump has not demonstrated a sufficiently cooperative and close working relationship between the Secret Service and Jack's office such that they should get materials from the Secret Service. And so the Secret Service has not acted meaningfully on behalf of the government. Same thing with the DOD, saying they're not closely aligned, and so Trump doesn't get access to their stuff either. Same with the ODNI. Both arguments fail. The indictment's reliance on a public report does not render that agency part of the prosecution. And the CIA. Now, Trump also says the CIA gave assistance to Jack. The court cannot agree, though. In the first place, any purported coordination between the CIA and Jack against Trump would not necessarily mean the agency was closely aligned with the prosecution. Give me a break. And for the reasons set forth, Trump has not shown the CIA is working with them. And lastly, it's the J6 committee, illegitimate. Trump says that the prosecution was closely aligned with Liz Cheney, but they're allowed to share documents, and this has already come up in other J6 cases, even Bannon's. Trump provides no reason to break with that precedent. Yes, they can share files, but they're only citing a news article. As Trump acknowledges, that newspaper article contradicted other filings, but they've already produced all the records they got from the committee anyways. And so there's no basis to consider Liz Cheney part of the prosecution team. And there's an order here, a demand for further immunity discovery, telling Trump to finish complying with my order about what other materials should be disclosed related to immunity. And so if you want other materials related to immunity, now's your chance, Trump. Go get it. And so Trump's motion to compel discovery is granted in part for those three little things, although that one is a big one because it shows clearly that Trump wanted the premises secured. And if you want to cause an insurrection, to cause a riot, to allegedly steal the vote, and to install yourself as the president, why would you create National Guard defenses to make it difficult on yourself? So certain things must be searched for and disclosed. Otherwise, the only people now who are part of the prosecution team are Jack's office, some US DC personnel, some people at the Inspector General's office, and some files at the Washington field office are accessible. Very small prosecution team and other orders. If the defense believes that they have not been given the materials they need, they can file to compel discovery by October 30th, signed by Judge Tanya Chutkan. And so, as expected, Judge Chutkan is doing no favors to President Trump and is limiting his ability to get access to a ton of evidence that is obviously a part of this case, keeping it very narrow. It's just Jack's team and a couple other small tangential things and materials that would be very useful to Trump in defending his case that is in the possession of these other agencies, like how many federal agents were there on the scene and so on and so forth. Not accessible because they're trying to rig the prosecution, just like they rig everything else. We're going to continue to cover this case. We'll see what Trump's team says in response to this, or if they appeal any of these motions on some basis. We'll be covering it. Thanks for subscribing as we do.